And what a beautiful morning this is. It has been snowing in this city of Toronto. I don't think my friend who is sitting on the other side of Canada on the west coast would agree with me. I don't think there's any snow there, but here it has been snowing. Today's video is not about express entry. So let me first get that out of the picture. This has got nothing to do with PNPs. This has got nothing to do with express entry or the draws, etc., because I know a lot of you would be wanting to know about that. So this video is not about that. This live stream is not about that. This live stream more so has to do with the regulatory proposals, Canadian forward regulatory plans, which was proposed for 2023 and 2025. We will talk about specific ones which are of direct impact to you, the listener, to you, the audience, as well as to us, the practitioners. So joining me live this morning is, oh boy, Steven Meurrens. I'm sure you already know him. He is a very popular figure on Twitter and otherwise in the profession as well. He keeps informed. I think he has the best access to all the ATIP notes that IRCC does not want people to know. Good morning, Steven. How are you doing?
Morning. How's it going?
Right. So tell me more about the forward regulatory plans, Steven.
A lot of people want to know what's coming up in the years ahead. What are the plans for IRCC? And one place that people can look is the forward regulatory plans. So IRCC, CBSA, all Government of Canada departments actually publish online their upcoming regulatory plans. So changes that they're going to make to the immigration refugee protection regulations all actually go up in advance. They do consultations through these websites. CBSA has one as well. And you can get a sense as to what's coming. It's limited to regulatory changes. So you won't see new programs that are created through ministerial instructions. They obviously don't talk about cabinet changes. We can talk about Mark Miller apparently is going to create a program for undocumented people. If that's done through a regulatory impact, through a regulatory amendment, it will be here. But if it's just through a public policy, that's not here. But all the regulatory changes are kind of announced well in advance because of consultations that are coming up. So you can at least see some of the changes that will be coming. Express entry points thresholds, unfortunately, not part of it.
Not part of it, of course. But which ones are the most interesting? Let's take that from the top. I have first one, which is the, this one should be interesting for a lot of people. Let me see if I can share that on the screen with everybody so they all have.
So there's a list of about 30 of them, and obviously we don't have time to talk about 30. So we kind of pulled out the most interesting ones. But again, anyone can go to the website. It's there you go, forward regulatory plans, and it lists different proposed regulatory changes that are coming up, the year that they will likely be introduced. And some things get added. If you go through the website, they add stuff as the year goes on if there are new policy changes that they want to implement.
Hey, but you know what? I'm interested about this one. Since out of the 30, you're going to speak only about 8 or 9 of them.
Yeah.
The top one, which is of very, very, a lot of interest to me personally, is the regulatory plan governing the council regulations made under the College of Immigration and Citizenship Consultants Act. So basically, that is the act that governs us as immigration consultants. What are you looking at on this one? So the regulations are being developed to support the CICC, and it includes a victim compensation fund, function and powers of the registrar, functioning of the college's complaints, ministerial powers with respect to the college, administrative seizures, management of personal information, governance topics. But I would have thought that this was already part of the CICC's functions. Wouldn't you think that?
It's quite something to me that they introduced the CICC without having this in place. And so I feel like, you can, do you feel like there's a lot of difference so far between being a consultant under the ICCRC and being a consultant under the college?
You really want me to say that on air right now? I don't have my license for too long and I want to keep it for very long. Okay, at the end of the day, practically it's the similar or the same organization. We are hoping to see more teeth with this new organization, sort of, so that they can actually implement some actions against the unscrupulous individuals inside and outside Canada. I'm not sure how much jurisdiction they have on people outside Canada, but inside Canada, they should be able to do something.
Well, this one for people inside Canada, yeah, I mean, all the consultants will be regulated by this. There's another regulatory provision coming in that I think is designed to target the ghost consultants. But this is just the actual regulations governing the college are only going to be, so when you read the link, it's consultations are supposed to be published in part 1. So that's where, the different individual consultants, KPIC, people can make submissions as to whether they think the regulatory changes that are being proposed are fair or not. One thing that I have heard discussed is the Victim Compensation Fund, and whether, so right now, I'm acting as an expert witness for the college, or at least the insurer of immigration consultants, in a case where a consultant is being sued. It's possible that under the Victim Compensation Fund that's being created, the ability to actually sue individual consultants, consultants, lawyers are a whole separate thing, but consultants will be restricted to what's actually prescribed in the regulations.
Okay.
So there's a lot of different ways that that this can go, and we'll finally see it at the start of 2024.
Okay.
2-3 years after the college is actually in place.
You would have wanted to see this earlier, but I mean, as long as there is some sort of a respite for people who are following the law and are actually availing the services of the licensed practitioners, well, there should be something to protect them as well. So let's see how and when this thing comes into play. I hope sooner than later.
Yeah. And I see Satinder Singh was commenting on our rain. No wonder Vancouver is also known as Raincouver. It's true.
I mean, I let me see if I can find that. I don't see that comment. Oh yeah, Satinder. Yes, no wonder Vancouver is also named Vancouver. Yes, of course. How much rain do you get in a year?
Too much.
Too much. All right. The next one I have is the regulations to establish a new system of administrative penalties and consequences related to the provision of immigration representation and/or advice. This also is pretty much about immigration practitioners. So people who, for people who don't know, who are watching this today, who are listening to us today, if you are availing services of an immigration consultant or a lawyer, paralegals are restricted a bit, but immigration consultants or lawyers, then you should obviously only be talking to those people who are licensed. So when I'm saying licensed means you can go and check on the regulatory body and see if they're licensed. Their names will appear and it will show whether they are active, suspended, or whatever that might be. This regulation talks about administering penalties and other consequences if there is any individual who is providing you immigration advice when they are not licensed to do so.
This is actually a huge change. So right now, if someone is a ghost consultant or providing consulting services without being a member of the college, a lawyer, a paralegal, depending on the province, right now under Section 91 of the Immigration Refugee Protection Act, they have to actually be charged. They have to, the standard is beyond a reasonable doubt. It's a whole, it's an act of basically a criminal. It's not under the criminal code, but it's a federal offense that requires someone to be formally charged and convicted. Okay. What the government plans on introducing instead is an administrative monetary penalty regime, which will take it completely out of the criminal process. And instead, if the government has reasons to believe that someone has provided immigration advice, they'll just fine them. The standard is much lower. It would be either on a balance of probabilities or just reasonableness. The fines will all be listed what it is. And so the ability to actually fine ghost consultants is going to be a lot easier and in theory quicker.
But would you think this is the way to go, or rather they should have made it much more stricter with the offense under the federal penal code?
The problem with the government's position would probably be that so a good analogy, I don't know if you have this in Ontario, but in British Columbia, the province decided that with drinking and driving, the criminal regime to address DUIs was too slow, too cumbersome, and taking too long. So in British Columbia, it's a whole regulatory offense where you can get something called an immediate roadside prohibition. And it's not done through the criminal courts, it's through the regulatory process. It's way faster. A lot of lawyers, initially didn't like it because they thought that there's less procedural safeguards. So it seems like that's what the government's going to try to implement, something analogous for immigration ghost consulting. I think it remains to be seen. You were talking before about overseas. I'm not sure how they would actually fine people who are overseas.
I mean, think about it.
People who are inside Canada, it could really put a damper on people doing it because the standard of proof is so much less, and it's just an immediate fine.
But imagine if it was only a monetary penalty or a fine, would that really deter all these unscrupulous individuals?
I think it depends what it is. So they have a similar regime for companies that breach the temporary foreign worker regulations. I don't think the fines are what deter most employers. I think it's the bars. But depending on what the fines are here, the speed with which they could be administered may be a deterrence.
Interesting. We got to wait.
I don't know. It's very. It will be. I mean, it will be a whole new area where there'll be a whole legal field that develops in terms of trying to challenge the fines.
Something what's happening with the traffic tickets at this point of time.
Yeah, and if it's just rapid fine, it could deter, especially just because the standards would be less. It would just be whether it's reasonable to believe or a balance of probabilities. The standards are so much less.
All right. Two specific regulatory proposals on immigration consultants. I just hope that this makes it better for people who are availing the services of these individuals, and at the same point of time, give them some better protection.
I think the big thing they need is an amnesty. So if somebody did use a ghost consultant, right now the problem's always been if someone used a ghost consultant, they're going to get hit with misrep and nothing will happen to the ghost consultant. So I think what they need to look at is some sort of an amnesty. Is the greater evil, getting the person who hired an unauthorized consultant or getting the unauthorized consultant? I think it's the latter, but so far the government.
But while we are on this subject, and since it's a great subject to talk to so many people who are out there who do get impacted, I know recently shared an ATIP about, I'm not sure which visa office that was, where they were talking about identifying through the ATIP itself, identifying how many immigration or rather how many applications have been submitted using unauthorized representatives. Do you think using AI to the effect, we don't really know the depth of the AI usage in IRCC at this point of time, but using AI, they would be able to identify which applications are being submitted by ghost consultants or actors out there? And would they take more stringent actions on those applications? As in, would they have a blanket refusal or a rejection, just like the way the applications are triaged right now? And Chinook and the other systems, by and large, refuse the applications.
So from what I understand, there's a software that they use called Watchtower, which tries to identify similar applications. So let me just pull open quickly. So here's just from a procedural fairness letter that someone sent me, which is based on your submissions and applications. This is the visa officer writing to the person. I have concerns that you omitted to declare that you used a compensated representative to facilitate the submission of your application. Your application contains evidence that it was facilitated by the same person or entity as many other applications received by this office. Based on our independent research, this is a compensated representative. I therefore have concerns that you've committed misrepresentation and blah, blah, blah. So they definitely, I think, are using these AI tools to identify patterns in applications.
Okay. And by that, would they really be inclined to send a misrep or a PFL to all applications, or would they rather just refuse the applications going forward?
I think they're inclined to do the PFL with the misrep to try to send a message. Because I don't know what'll happen in the host country if everyone who hires the same ghost representative, if all that person's clients gets banned from Canada for 5 years, there presumably will be some sort of consequence within that country.
Okay. All right. Moving on with our regulatory plan discussion there. This one I'm quite interested to see happen. Amendments to excluded relationships in Section 1179D and Section 125 of the Immigration and Refugee Protection Regulations. This one basically talks about foreign nationals that have not been declared and examined at the time of the sponsor's application. So just to give people context of what I'm talking about. So it's quite common for you people out there, as and how you are waiting for your application. Let's take express entry. So as and how you're waiting for your express entry application to be processed, there are obviously times when there are changes in your family composition. So you decide to get married. By the time you get married, for whatever the reason might be, whether you're misguided, whether you don't understand it well, you do not inform IRCC about your marriage. You become permanent resident and you land in Canada, and now you want to sponsor your spouse. At this point of time, because you were married during the processing of your application, or in some cases even earlier, because you wanted a lower score, you chose not to disclose about your spouse at all. Now you are a permanent resident, and now you think you can sponsor your spouse. So under normal conditions, as of today, you will not be able to sponsor the spouse because you were already married when your permanent residence application was being processed, when you are not here. As per the regulations, they have to assess inadmissibilities of your spouse as well. Because if your spouse is inadmissible, that also makes you inadmissible for permanent residence. Because your spouse was not checked for inadmissibilities, therefore, this person is now referred to as a person who is not considered as your family member for the purpose of immigration application. There is a proposal to change this regulation. Am I right, Steven?
Yeah. And it goes like the one that it's not just if they were married and they didn't declare it. Like the one that I think hits people from China, India, a lot of other countries is if they were common law.
Yes.
And the problem is common law, you can correct me on this if I'm wrong, but common law isn't a thing in India, and a lot like common law relationships. And so a lot of people, say from India, who are living together here as, say, international students, boyfriend, girlfriend, they may be living together in a house with other people. They don't realize that under Canadian immigration legislation, they're considered to be common law. And then what winds up happening is down the road, they get married, they try to sponsor their partner, and IRCC says, well, you can't because you were common law when you became a permanent resident.
I've had this application very, very recently, I think just about a month back, whereby they were sent a PFL saying that the applicant was not eligible because he or she was considered as an excluded family member, since the permanent resident spouse did not disclose the relationship at the time of the application. Yeah. And now we are looking at Section 25 and trying to sort of see if we can do an H&C, because there is no other option in such cases.
Yeah. So this is what they're considering changing. So right now there's a narrow public policy that within the family class, people who were not declared and are now trying to sponsor someone can sponsor them. And it looks like with the regs, they are considering broadening it so that this won't apply to anyone where the declaration or non-examination would not have materially impacted the sponsor's application for PR. So a classic example would be, and someone recently consulted with me on this, someone who applied in the TR to PR category didn't declare that they were in a common law relationship. That wouldn't have impacted eligibility to that program really at all.
It wouldn't have. No.
And so, this under this proposed regulatory change, they would now be able to apply for common law, whereas right now they're experiencing complications.
Yeah, and just to clarify, the material change here, or materially being affected here, is, for example, if you're already married and you are submitting an express entry profile and an application, and you choose to show yourself as single, though you are married, because it impacts your score. then this would be considered a case where your spouse would not be accepted, because this is where it is materially affecting your own eligibility as a permanent resident if you were to file your application.
Yep. And what they're trying to get at, like the original logic behind the rule is that, for example, like if you sponsor your spouse, then if they are medically inadmissible to Canada, it doesn't matter, right? There's an exemption from medical inadmissibility to spouses being sponsored. So what they were originally trying to avoid was people who say have a sick spouse immigrating to Canada, because if they try to immigrate, if you submit, if you're a foreign worker and your spouse is sick, such that they would be medically inadmissible to Canada, and you apply for permanent residence, the fact that your partner is sick would result in you not being able to immigrate as well. What they were trying to avoid was people just saying, well, I'm single, they immigrate, and then they turn around and sponsor the spouse who's sick. So by materially impact, it could even just be as simple as like the person's not criminally inadmissible or medically inadmissible. They could actually be going for something much broader than even the sponsor's program eligibility.
Sure.
So it'll be a very interesting change to watch, and one that, again, is especially with international students and grads, becoming increasingly common, where international students who live with their boyfriend or girlfriend have no idea what common law is, are getting caught up in this.
Yep. Well, let's see when this one gets done. When they say 2023 to 2025, that's quite a broad spectrum in terms of the period. 2023 is already gone, so we are now at almost, at the brink of.
I think they want to do this one soon because they have the public policies in place. I tweeted yesterday, or X'd, whatever the verb is now, an ATIP which says that they're really there's a memo to the minister that they are trying to get these regulations developed, but just other issues, took priority that developed during the year.
Okay. What do we have? The next one is the amendment to the citizenship regulations to provide greater flexibility in the taking of the oath of citizenship.
Yeah. So this one doesn't, I'm curious. I included this just to get your take on it because it generated a fair amount of controversy at the time about whether people would have to do the oath in a room versus just a test and click a button that they did it. And so in theory, skipping citizenship ceremonies. I don't care, but I'm curious, what's your, I don't attend the ceremony or don't. I don't really understand what the big deal is. I was just curious your thoughts.
So I think I fluctuate with this one. On some days I'm this side, on some days on that side. So I think what the debate also, first of all, for people who are looking at this screen right now and wondering what are we talking about. So earlier, this is pre-COVID, if you were making an application for citizenship, if it was approved, of course, part of that is to take an oath. And then you are swearing your allegiance then to the Queen, now to the King, and therefore then becoming a citizen of Canada. That was always an in-person event, unless there was a requirement for an accommodation where you could then, do it otherwise. But during the COVID, and of course during COVID they couldn't do it, and then after once the COVID restrictions were relaxed a bit, then they started doing more of these online. Therefore, they would get everybody on the Zoom, 30, 40, 50 people, and they would then have you, snip your PR card in front of the camera, and therefore then making you a citizen after taking the oath on the camera. Now, there was a lot of talk about, and there is the proposal that they should actually regularize the online or the virtual way of affirming your citizenship. And the debate basically is from people who consider this to be such a moment, a milestone moment of your life. I mean, you are now becoming a citizen of a different country, that by making it virtual, you are taking away the sentiment and the emotion from it, and probably the value that you should be providing more to something of this sort. So therefore, the debate was in the favor of making it virtual rather than not. So as I was saying, I sometimes fluctuate on different side of things. Yes, virtual is the way to go forward, right? I mean, that's with everything going remote and with the way artificial intelligence coming in, I'm sure very soon, after a few years, we will all be operating out of our pods, and our avatars will be out there actually doing things physically. But I'm sure
Canadian metaverse.
Absolutely. But I think we're still way away from that point of time. And at this point of time, I think considering that becoming a citizen should be a huge deal, should be a big deal. It should not just be a mere paperwork process. Because if you as a government are now reflecting or are now indicating that this is what it means to you, that this is just a paperwork process and you want to get over with it quickly with a touch of a button, then that is also the impression that people are taking in and then are treating it. And you would rather want this to mean a bit more to people. So when you come into an in-person event and you are then interacting with another 30, 40, 50, 60, 100 people who are also now becoming citizen, you get a chance to maybe exchange some stories with other people. It's a moment of time which is then frozen in your history, in your memories, right? This is what happened when I became a citizen, versus you just wearing something on top and just clicking a button, being in front of the camera and saying, okay, how soon will this thing get over so I can now become a citizen and apply for my passport and then fly to one of the European countries where you couldn't get a visa otherwise.
How many months would you be willing to wait extra to have that ceremony? If you could click.
That's what I said. I fluctuate on sometimes, because of course, if it's an in-person event, then it will take more time to schedule one, to arrange one, to organize one, rather than a Zoom, which can be done pretty quickly, fairly quickly. But I think I still tend to favor more the in-person rather than the Zoom, just for the fact that it should mean something more to you rather than just a click of a button.
Yeah. Have you been to the website disavowal.ca where people disavow their oath?
No, I haven't seen it yet. No.
It's an Irish guy, of course, introduced me to it, and it's just I just went to it now. Like, it's filled with people who are public, like they're citizens now, but they disavow the oath and their reasons for it. It's interesting.
I mean, come to think of it, I mean, until when are we going to be swearing our allegiance to the monarchs, right?
Or how long will King Charles be on our money? I think it's like, I mean, it would require a whole new constitution to change the constitutional monarchy that we have. But I do think that swearing our allegiance to a family that lives in a different country
and who have absolutely little to no say in how our lives are impacted.
And I think, I also have an issue with hereditary. Anyway, there's a whole
it's a different
hereditary versus merit.
All right, so that was the citizenship regulations. The next one is remove or amend the requirement to present a permanent resident visa to an officer at a port of entry or IRCC inland office for approved permanent residents residing in Canada. This was indeed a big one, thankfully, which was brought forward and put into effect during COVID. Stephen, what did you think about this one? I mean, I was quite impressed. I should do it so quickly.
That they brought it in. I was impressed. I see that somebody in the comments, Fiza Uzair, said Stephen needs to get an ATIP on ECOPR process delays. The delay is devastating. And that's actually where I land on it. So prior to COVID, people who were approved would go to the border if they were inside Canada for the most part. And CBSA would briefly interview them. And they would get their they would get their COPR, their confirmation of permanent residence, on the spot.
Yeah.
During COVID,
there'll be flag polling.
Yeah. During COVID, they didn't want people going to the border. So they introduced this new landing system. And I initially thought it was going to be a temporary measure. It looks like through this regulatory change that this is now going to be the norm. And this is going to be the new process going forward. The delays right now are astronomical. Like, it's insane. And
help me understand this. So first of all, for people who still do not have the understanding of this background, earlier, I mean, everybody had to get a PR visa stamped on their passport unless they were from a country which did not need a visa, or they were from an ETA country. So they needed to then come to the border. At the border, they would present their credentials in terms of their visa or ETA, and of course their COPRs, which were already issued and sent to them. Therefore, then signing the document and then becoming permanent residents. During COVID, initially what they did was IRCC officers started making a phone call. So they would call you, confirming you're inside Canada. Once you would say, yes, you're inside Canada, they would consider that as a virtual landing process, and they would email you your COPR. That was how it started. Then they created the portal, whereby now you are sent what people do refer to as portal 1, portal 2, though I do not know where the nomenclature comes from. So first you get an email confirmation saying, are you inside Canada? You would say, yes, you're inside Canada. After a few days, you get a portal request, whereby then you will upload your photograph, which usually goes for your PR card, and then confirming your address. Once you confirm that, then you then receive through your account or through your email a COPR, which then confirms your permanent resident status. Now, in essence, this is a great move. It completely takes away a huge red tape and a bureaucratic process, I would say, because this whole process of appearing in front of a visa at the border did not make sense anyway. So the good thing happened here. But Steven, why so much of time? Why
is it so long?
take
I have
so
no
much?
idea.
I mean, you're first asking me, am I inside Canada? I say yes. Then you are sending me the portal request. Good. I now upload everything so that you now have my picture to make my PR card. Understandable. After that, why does it take time? As of today,
I have no idea. Like, I recently had to, in BC, we have something called the Services Card app. And mine was out of date. I had to download it, reinstall it. And that app, you have to input some data. You take a picture of yourself. You say, you have to nod. You say the word bat. They say someone will review it and get back to you. Took about an hour, right? Like, and obviously there aren't as many people doing it, but the point is the process is quick. Right now, so instead of driving to the border, taking maybe 2 hours out of your day, getting it signed, which was a bit of an odd process, but like at least it was quick.
Yeah.
As you said, like it's taking forever. And what's frustrating, so it used to be like the annoyance, you'd go to the border, you'd get your COPR, and they'd say, okay, don't travel until you get your PR card, which could take a month or two. And that was always a bit, we used to call it like, you've got your PR, now you're in Canada jail. You can't go anywhere.
Yeah, you can't.
But now they don't want people going as soon as they hit create the portal, because they say they can't confirm your status if you're outside of Canada. And that's taking months. So we've like doubled the time that someone is in the jail.
Yeah.
One theory that I've heard is that the reason the delays are so big now, I don't know if this is true or not, is that they've hit their levels target for the year, or they're very close to hitting it, and they don't want to blow through it. Yeah, and if they confirm all these PRs, then those are all PRs in 2023, and they may look like they overshot their numbers. And there's this narrative right now that the Liberal government has lost control of immigration. So so they may not want to overshoot the numbers. I don't know how true that is. But that is one theory as to why it's taking so long, because otherwise, as you said, I don't understand what could possibly take so long, like to confirm it's all attestation based. Like, are they in Canada? Yes. Like,
yeah, this was something which will always remain a mystery. But anyways, this particular regulatory plan is now already in effect, and therefore I just hope they streamline it so that it becomes better. But while we are talking about all of this, something great has again happened, and that is draw number 276. Yay! Another express entry draw. This one which has just happened is a trade occupation draw. Total number of invitations that have been issued are 1,000 with a lowest score of 425. Well, as I said in my video yesterday, that since they have conducted a regular or general express entry draw now that they now call it yesterday, which was Monday, then it was expected that they would be conducting some trade occupations draw for this last week. Hopefully, I'm not sure if this is going to be the last week, but I think technically it might be the last week for express entry for this year. So as expected and anticipated, trade occupation draw has been conducted, 1,000 invitations and score of 425. I was hoping for the score to be actually lower than this, but this shows that more and more people are now entering the pool even with the trade occupations. So
nice. Housing crisis solved. We invited 1,000 tradespeople.
Yes, I mean, that is.
We should talk like it's for general people who aren't part of these category draws. It's a disaster.
It is, right? I mean, and I know we don't want to talk much about express entry today, but very quickly, because that is such a huge subject for interest. I know they want to invite the PNPs, and that's what they did in yesterday's draw. Though they called it a general draw, they invited 1,325 people. Technically, they just cleared out the pool of these 1,011 people who probably are largely the PNP nominees. Do you think also this has to do with the end of the year and therefore the number of draws being so small?
I think it's a combination probably of a number of draws being small, provinces needing to hit their quotas,
Yeah.
and the IT issues that they've been having. So they probably also are a bit wary of doing a huge draw just because of the IT issues. So I think it's probably a combination of those things. When we interviewed on Borderlines, former immigration minister Chris Alexander, he said the thing that made him and everyone in the department the most nervous were IT issues around express entry.
Yeah.
And I would imagine that continues now that they are experiencing them somewhat.
I can imagine. I can imagine.
So that's what I would think. I think though, like, have you told, like, I'm sure you've discussed it with you, just how tough the points are going to be in the future because they're freezing permanent residence levels 2025 to 2026. And they are increasing the proportion that are going to be francophone.
Yeah.
So for everyone else, it's going to be a tough few years.
I mean, I know you've done your borderlines about your crystal ball. You don't call it a crystal ball, but your predictions for 2024. What do you think? What is your biggest prediction for express entry?
For express entry, that's going to be brutal. Yeah. I think the points are going to be very tough. I think the narrative right now on immigration in Canada has shifted. I think going into an election where housing is so dominant that, well, they froze the numbers. Of course, the minister also apparently is going to introduce some sort of a program for people out of status. If that happens, I mean, he's presenting a plan to cabinet. Cabinet may say now is not the time. But I think for express entry, it's going to be tough. I think they're going to lower the thresholds for who qualifies for the francophone immigration.
Yeah.
Match the new work permit, because like it doesn't make sense to have lowered the standards for the francophone work permit so that people can come here and work, but then those people won't have the points to qualify for permanent residence. So I think there'll be something there, but otherwise I think 2024 will be a year of high express entry points and backlogs.
Wow. Okay. I mean, that doesn't sound very nice for a lot of people out there, but then we've been saying this for almost a year anyways, that the PR process, not the process, but the whole, what you can or cannot do with your points is becoming very difficult. I mean, technically for an individual who's young, as in 29 years or below, with a master's degree, 3 years of work experience, IELTS at CLB 10 or language scores at CLB 10, single, outside Canada, you can only score 481. You can't do anything more than that. I mean, so what does that person do now to sort of, make their way to Canada?
It's hard. So something's like, I'd say the other thing that I got wrong was I didn't, when they introduced category specific draws, I thought they were going to give themselves the ability to do it, but I didn't. And I actually thought it would be targeted at Ukraine initially, which I was wrong about. But I didn't anticipate that it would become so so regularly used that the points for everyone else would soar, such that it almost feels like there's more people being invited through the categories than the general program. So I'd say that was probably my biggest mistake of a prediction.
On that one, I think I got that one right, because the minute even before they announced the categories, if you remember last year, Motion M44 did the rounds, right?
Yeah.
Randeep Sarai of Surrey, he asked Sean Fraser to sort of do something for people who did not have that high scores, who are from trades, and that is when Sean Fraser released that 5 pillars of strategic move from becoming a permanent resident. In that, these categories were indicated, and that sort of told you that point of time itself as to which way they were heading.
Yeah, I didn't anticipate the frequency. I thought it would be more a political one-off, but instead
because in that 35-page document, Steven, there was only one single sentence which spoke about people who are outside Canada and said that they would have to do something for people who are not in those categories. So that, because there was very little attention paid, that itself gave that indication that they were probably going to target more the categories rather people who are not in the categories.
Yeah, I mean, I've voiced my thoughts here about what I think about inviting people who are like, yeah. I mean, I wouldn't have a skilled worker draw until the CEC pool was empty, but
I was going to ask you the same question.
For the entrepreneurs, the CEC doesn't allow entrepreneurs. Like, I just have a problem with people overseas getting invited ahead of people in Canada, but the government doesn't. So it's what it is.
I mean, I know you've been advocating a lot for CECs, and I have seen that. I mean, in our previous discussions as well, we have spoken about this. But for some reason, IRCC is just not interested in CECs. They think that after giving them 35 or 40 points in their express entry, they have done their bit for Canadian experience class.
Yeah.
But with this current scores, they are probably ruling out tons and tons of people. And now with them, announcing that they are looking at pathways for 300 to 600,000 undocumented workers, what are they doing? Are they not encouraging more people to probably become undocumented?
Well, we were joking that we should be telling CEOs to get out of status because it will be easier for them. The other thing I don't understand with like express entry is the skilled trades category, when there's a whole skilled trades program that they never do draws in.
Surprisingly, yes.
Yeah, like I don't understand why there needs to be a special category within the basically federal skilled worker and CEC for skilled trades when there's a program called Federal Skilled Trades Program that they never invite people in.
Because in the federal skilled trade categories, all knock codes with 7.2, 8.2, 9.2 series would be eligible. Under the category-based draws, you only have 10 knock codes that you're inviting.
Yeah.
So
I think you might be right, just to exclude the cooks. Exclude the cooks and the chefs.
Yeah, I mean, again, there are so many things that don't make sense. And sometimes, in my weirdest of nightmarish dreams, I dream of being the immigration minister. And the things that
Why would you do that to yourself?
The things that I can do to make this so much better. But then sometimes, we all have, just for example, I'm not sure if you follow cricket, right? But if you're watching the match of cricket, and I'm sure the same thing with basketball or hockey, you are always, as an audience, thinking, oh, this guy should have done it this way. This guy should have done it this way. But you do not know what's happening with that person on the field and what is that person going through. So I guess sometimes you don't know what Mark Miller is going through in terms of what pressures are on him from his political party, from the government, from people, from different lobby groups and other peers. So I guess...
I want to touch on Bivens before we go to the next regulatory. The rigidness of IRCC requirements related to work experience is continuous. What about people who work on ships? As far as I know, I've seen discussion at the policy level about this rigidness. I'm not aware of visa officers being that strict on it. But yeah, I don't know if you've seen different. I've heard increased chatter about this, but I haven't seen it at the officer level. Only really at the policy level.
Same here. Nothing much that I have come across at this point of time.
What's the next reg?
All right. The next one is, let's get there. This is cancellation and refusals of certain temporary resident and other documents, amendment to the IRPR. I'm not very familiar with this one. Help me with this one.
So this is just the ability to clarify the ability of what is required to cancel a document. So right now, if someone comes to Canada on a TRV and they have an issue at the border, so if someone comes on an ETA and they have an issue at the border, it's clear that ETAs can generally be canceled. And this would just broaden it and extend it possibly to TRVs, work permits. And so it's just interesting that it's another example of where they're moving to streamline things for efficiencies, to make it more easy to cancel visas on the spot without, say, procedural fairness letters and things like that. So it's just included as something to watch for in terms of the ease with which they are going to be canceling things.
Okay, on that note, have you noticed the most recent public policy revocation that Mark Miller undertook? He revoked the public policy of February 28th, where TREs were issued without checking Section 204.
That was supposed to only last until this December.
Yes, but not only that, with that revocation, they have also indicated that CBSA will now have greater authority in making the assessment whether the person who's entering Canada would or should is complying with the 205.
Yeah, they should. I never understood. I thought it was, and I'm surprised it hasn't gotten more press. For those who don't know what we're talking about, the government, in order to clear their visitor visa backlog, essentially bulk approved visitor visas that had been in process for some time, which, fine, clear the backlog. But what they also did was they told CBSA that if someone arrives on one of those visas that was bulk approved, CBSA couldn't look at whether they would leave Canada by the end of their authorized period. It frankly made no sense. And now they are able to, if someone shows up on one of those visas and is like, I have no intention of leaving, they can now, send them, they can now deny them entry, write them up for having a permanent purpose, something like that. Whereas there was this weird waiver. And I don't know if you follow Ghosts of CIC on Twitter, but he was saying that, I don't know if it's a man or a woman, was saying that there was a huge increase in asylum claims from people.
There is. The numbers definitely indicate that.
Yeah. So this is and so all of this is they're bringing in the ability to cancel visas more easily.
Yeah, this was that. Right. Moving on to the next regulatory plan. IRCC to modernize issuance of immigration credentials in the Visitors, International Student, and Temporary Workers Program. Okay, so when they refer to credentials, are they just talking about moving away from the counterfoil, which you have been talking about?
This is it, the e-visa that we've been talking about. It's coming. Okay. No more sending your hopefully, no more sending your passport in. No more, sitting around waiting for it to be printed. It looks like they are moving to digital visas, and the plan is, they only added that the estimated date they're aiming is it's a ways away, 2024, 2025. So either later in the year, this next coming year, or early after that. But they are going to finally be getting rid of the print your visa, put it in the passport. God, yeah. I wish they would do the same for PR cards.
Yes, I agree with you. I don't understand the whole purpose of it, but I guess somebody gets paid to do what they're doing. So
yeah, someone's got to work.
For people who don't understand, who don't realize what we're talking about, for people who do not need for people who need a visa on their passport, what they have to do is, once their visas get approved, visa could be anything: study visa, work permit, visit visa. They have to then send their passports to VFS, who will then send it to the Canadian Embassy, where they will then print out a visa for you, stamp it on your passport, send it back to you, using which you will then be able to travel to Canada. This amendment is talking about removing the requirement of slapping a visa on your passport. They will probably issue some sort of a digital visa. Yep. Once you apply, you will have that digital number or a barcode or whatever you want to call it. You would then be able to carry it with you, come to the airport, show it to the staff, who can then probably scan it to validate if it is genuine, valid or not. And then you will then be able to travel to Canada. The only loser on this particular segment would be VFS, yep. who would then not be able to make money off you trying to send your passport, who basically acts as a courier service. They take your passport, send it to the embassy, get it from the embassy, give it back to you. So yeah, I guess this one is to look forward to for sure.
Does VFS charge for biometrics? Is there a fee on top of it, or is it built into the?
No. So this is what VFS does, and this is my pet peeve with that particular company is when people go for biometrics, they don't have to pay their fee. They just need to show their biometrics instruction letter and their passport. But what they do is they coax the people into believing that people should avail their premium services, and they sell it as if you don't avail our premium services, then your process will get delayed. You may lose your passport. You may not get your passport at all, or there could be certain other things that will go wrong with your application. Now, that is fear mongering. That is sort of them creating, some sort of a feeling in your heads that what these guys are telling you is that they can impact your application. And by availing these premium services, which are ridiculous, which basically just allows you to sit on a more comfy chair in their premium lounge, probably have an access to a cup of coffee and a biscuit or a cookie. That's it. And for that, they will charge you about 3,000 Indian rupees, which is equivalent to roughly $60 for a premium service, which has zero relevance in the whole application.
Hopefully it's a very comfy chair. That's
yeah. For $60, yeah, it's a very comfy chair. But yes, that's what they try and push you into, rather.
Yeah. No, I can't wait. I mean, yeah, I wish they would do the same thing for PR cards.
That's another one. Okay, so regulatory amendment to the IRPR concerning the provincial nominee class. Which one is this, Steven?
So there's no real details about what it is beyond that, and so I'm curious. What do you think? They're negotiating with the provinces. What I have seen in my judicial review practice is a big uptake in work permit refusals for entrepreneurs and debates over who gets to, does IRCC have to respect the provincial determination as to whether someone's business in the PMP is going to be a significant benefit. And I've even had cross-examination of people who write the IRCC manuals and the online guidance. And I can send you, if you're interested in reading, IRCC's take on this, which is that their officers, if someone is if someone gets a work permit support letter for a business, IRCC's position, at least at the policy level, is that their officers don't have to show much discretion to that, and they can do their own assessment. And so there's been all sorts of litigation around it. And I just wonder if this is to try to clarify in the regs that, yes, they have the ability to do that. Because, yeah, it's to clarify roles and responsibilities. So I think IRCC wants more control, is my prediction.
I would have thought provinces wanted more control, because in the recent meeting with the ministers from provinces, immigration ministers from provinces, as well with Mark Miller, they have been exerting that they need more control, more authority over their own applicants, rather than IRCC going ahead and then
So I think the provinces want control too. Like the one of the provincial nominee programs has asked me to see the affidavit that IRCC filed in one of my cases around this, and I think IRCC wants more control. I think that there's a few provinces that maybe their nominee programs are having higher refusals than others, and the IRCC just it's kind of like how Mark Miller has taken to kind of warning the provinces over schools, that they're going to start directly regulating like trusted schools. I think IRCC wants greater control over who's getting nominated. Again, this is me pontific. We know there's some change coming. We know there's negotiations, and that the government wants to clarify who's responsible for what. I think they want, I mean, my guess would be they want more control. I think the provinces, as you said, feel very strongly the other way. But something's coming, and yeah, I think even right now, like, look at the changes to provincial nominee work permits, right? Like a few years ago, you would say, oh, if a province has given you, approved your business, you're very likely to get your work permit. And look at the guidance now that changed earlier this year, where it's pages on how you still have to satisfy IRCC regarding significant benefit.
Yeah.
I don't do a lot of business programs, or business immigration programs, but from what I hear, it's just become much more complicated.
Yeah, I mean, for all C10s, C11s, C12s, the burden of proof as an applicant has just gone tremendously up in terms of what you need to provide and indicate and state as to what the significant benefit would mean for Canada. So that is totally a different ball game here. But as far as PNPs are concerned, I mean, from the only thing that I gathered from this was that provinces probably need more authority or control over their own candidates and programs.
Yeah. Olu says in the comments that the VACs also charge for using text services. I'm curious what they charge for that. Is that part, is that also $60 to get?
Which
Next
one is
update.
it?
Someone in the comments named Olu. I hope I'm pronouncing that right. Olu.
Oh, this one. Olu says they also ask for other services for things like SMS fee to get updates or track your application. Yes, absolutely. So this is also part of their upselling. So what they say is that give us your passport, we will send it to the embassy, and if you want to receive SMSs to track that when has your package left our facility, it has reached IRCC, when it has dispatched from IRCC and reached our facility, for those you will get SMSs and you need to pay more for that. So
yeah, so yeah, okay.
that's another way to make money, right? I mean, and to consider that they have just recently received another huge contract to handle the UK visas across the world.
Yeah.
So,
I mean, on that one, I guess like there is some value in knowing. Well, I don't even know what steps. So the VAX, I guess IRCC updates the VAX as to when they stamp the passport, or
no, so what they do is it's just what they're offering you is a courier tracking service.
oh, it's just courier. Like,
Yes.
oh, okay, yeah,
So
yeah.
they can't tell you when the VAC has done anything. Actually, it's your own GCK account which tells you when the VAC has
Oh, yeah. So
stamped your
when
passport.
IRCC stamps the passport, that's in the GC key.
Yes.
And so they're just, it's like it's basically giving you a tracking number and they'll text you the update.
Yeah, it's not even giving you the tracking number. It just tells you, okay, your package has left VFS, it has reached the Canadian embassy, and then it has been dispatched from Canadian embassy, and it is on the way to you. So 3 or 4 SMSs is what you get for some extra bucks.
When you're a monopoly, you get
you can do that. Yes.
do that.
All right. What do we have here? Yeah, this one is from CBSA talking about membership. I guess this has more to do with the security.
Yeah, so CBSA gets to actually CBSA last week took one of the proposed regulatory amendments from the list, and it wasn't one that we were going to talk about, but they published it. So for those who are kind of curious again about what we're reading, you can see how something in the forward regulatory plan looks when they actually publish their proposed regulations. That was about something super complicated involving port of entry refusals. This involves membership, and why I thought it would be interesting to talk about is just given the new security concerns that are spreading, and last year they designated the Islamic Republic of Iran as being a regime that systemically violates human rights, which means that everyone in the top half of that government, public service, military, is inadmissible to Canada. And so it looks like they are now proposing changing the test. And you can provide input as to what you think the test should be. I just thought it would be interesting to include here because I don't think we've discussed, it kind of slid under the radar a bit that they had designated Iran, as the Iranian government, as being this regime that systemically abuses human rights. And we're at this weird point now where like Canada's diplomatic relations with China are strained, India are strained, and where everything is going from a security perspective. You know, I think before 2018, people from China wouldn't, think that their applications would all be delayed security wise. Then the Meng Wanzhou incident and the 2 Michaels happened. And now it's like delays for anyone with a STEM background from China are astronomical.
Absolutely.
Russia, obviously, since the war in Ukraine is delayed.
Yeah.
India, I think it remains to be seen.
Haven't seen much at this point of time, but if with individuals with certain military background, there usually are delays anyways, just like with the people from any country who have any military background. But other than that, nothing specific as such.
Have you noticed the decline? I saw something called the Hinduistan newspaper online or something was reporting a huge drop in study permit applications from India.
Yeah, we will talk about that the minute I finish the last regulatory plan, because that's what I'm keeping my last 5 minutes for, to talk about whatever has happened in terms of
so yeah, I mean, I would just something to monitor here, especially if you're from Iran, I guess, is that they might change how they do this test.
All right. And then the last one is about the regulatory framework applicable to the definition of senior official. This also
Same idea.
is relevant to the previous one, whereby IRCC can identify certain individuals from different countries and depending on their regimes as to what role they may have played within the.
And there's another one that's going to get added from what I understand, which is last year Parliament passed something which makes you inadmissible for sanctions. So if you're a person or a company, or you work at a company or a government that Canada sanctioned, you're now inadmissible as well. And as with the College of Immigration Consultants, the law passed with no real regulatory framework for what it means. So I think the regs are still in the drawing board on that.
Yep. Last 5 minutes, your thoughts on the most recent changes as far as the international students were concerned. I mean, I know international students are getting a lot of heat, some for the right reasons, some for not so right reasons. But yeah, what were your thoughts?
I think that the increase in required fees makes sense.
Yeah.
I think reducing the amount of hours that they can work doesn't. That's kind of where I balance it. I do think I mean, I don't do too many study permit applications, but like the last one I did for someone in Vancouver, when I read you need $10,000 a year to live here, when like that won't cover rent, let alone food.
Yeah.
So I think it's also sensible that they're tying it to inflation. I think the overall the messaging on international students is I don't know what the word disgusting might be too harsh, but like it's very unfortunate how it's gone from, especially for people who are already here, who have paid so much money to study here, who were essentially told, the Canadian government likes to say like, well, we never told people that if they were an international graduate that they could have a pathway to permanent residence. And it's basically like, if you've been doing this long enough, yes, they basically did, right? Like that was the messaging. And I think both how hard it is to qualify for express entry, as well as just the messaging around international students, the fact that we don't want them working off campus. They should be studying only. They shouldn't be gaining work experience, which would actually is as valuable as studying, is terrible messaging. I do think it's really weird that before there was no way to verify with the schools that someone had a genuine acceptance letter. Like, and again, they're like targeting the schools for this, it seems, but it's like, really, that's IRCC. Like, how is that not in place before?
I mean, I've had several mixed thoughts about how this whole thing is being played out. I mean, anything that Mark Miller did in this most recent announcements, that to me personally was not a shock, because I honestly did not expect that they would be extending the postgraduate work permits that were expiring. I mean, there was only so much that they were going to do with that. The fact that they allowed international students to continue working full-time, I was surprised. I thought they would not extend it. So they did. So thankfully for a lot of people who were struggling to make ends meet and needed to work full-time. So that's good for them. The fact that they increased the amount of funds that you need to show to come and study in Canada, I think that's quite fair.
I don't know why it's not.
I know a lot of people don't like it.
Why it's the same countrywide? I don't understand that. Why it's not based on provincial, like why it doesn't vary by province.
It should, right? I mean, I think it should be more for BC and Ontario, and less for
Manitoba. University out in the Maritimes has a big problem. You know what I find interesting too about Mark Miller, and I think people try to read into what he tweets, but I'm convinced that like when he tweets, I think he's just copying the head, like any article that he's quoted in. I think he just copy and pastes the headline.
Yeah.
And people are taking it as that's what he's saying. But I don't think that that's what his Twitter is. I think his Twitter is just a series of headlines.
It is.
They aren't his words, but people seem to take he said this, and I think he's just retweet every news article that he's in. I think he just tweets the headline and people confuse it as being him saying this is his policy.
No, actually, I think what he's been doing is he's been tweeting the text where he has been quoted, and he puts that on the Twitter, and then underneath the link of that particular article. That's what I have seen in some of the articles. I'm not sure about all of them.
The other thing I
Because
find weird is how he's so throwing Sean Fraser under the bus. Like every statement is like, for too long, nothing's been done on this, and it's like, well, it's your ministers, right? Like it's Sean Fraser, Mendocino, Hussein, McCollum. Like it's been your government for 10 years. Like you're really throwing.
But then what do you have to say about what Sean Fraser has been saying, who is now the housing minister? But his latest statement was that they are absolutely looking at stemming the numbers of international students and new immigrants into Canada because of the housing.
Immigration Minister Fraser's biggest critic is Housing Minister Fraser. Like Housing Minister Fraser seems to have a really big problem with what Immigration Minister Fraser did. Like it's interesting to watch. I have no idea where that's all going. And what I hope, because they say they want the schools to start providing more housing to international students.
I'm not sure how I'm going to do that.
Well, I hope it doesn't turn into like the school saying, okay, domestic students no longer get to live on campus, only international students.
Yeah.
Which would be the easiest way to do it. And then that will have its own backlash.
Absolutely.
So
absolutely.
Really not, it remains to be seen again, him kind of threatening the provinces with respect to DLIs. And it was interesting, not a single province reacted, it seemed.
I mean,
to the wind.
The way Mark Miller actually lashed out and made that simple threat saying that enough is enough, and if you guys don't do it, I will have to do something about it. I thought at least Doug Ford is going to come out and say something, but no, nothing.
No, I think and it's just interesting. I can't really get a sense of what's going on. Like even that announcement about some program for the undocumented, and it's like, that literally 1 month ago they said they were freezing immigration levels. So is that canceled? Like, is this program on top of existing numbers? Is it to take away from express entry? Like, it seems to be so reactive, and I can't figure out I'm going to stick with what I said. It just sounds like someone yelling into the wind different things without there being a consistent message.
I'll bring you back on January early, so then we can talk more about 2024 and the crystal ball as to how it's looking. I want to wait for at least the first 1 or 2 express entry draws in January to draw some inference as to, was it the end of the year that was holding them back, or did they have something else up their sleeve?
Yeah. I mean, that will be interesting if there's a big flurry of approvals also in January. Then was it just a numbers issue led to all these?
It seems like, because in my opinion, and I'm sure the numbers will come out and probably prove that, I think they've already touched or probably even crossed 500,000 for this year.
Yeah.
Because they were going pretty strong at the halfway mark, and everything suggested that they will cross 500,000 for this year. And I'm quite I'm expecting to see that number, if not 500, at least pretty close to it.
Yeah.
And this, what we've been talking about, the delays in the COPRs and being issued, I think that has pretty much to do with that. Otherwise, there is absolutely no reason why they would be holding those back.
No, and I can't imagine that 2 years into virtual landing, all of a sudden they forgot how to do them quickly. So it's it's just, I don't understand how stuff like that happens, where for 2 years it's going smooth and then
it doesn't happen.
Yep.
Steven, thank you so much. Thank you for joining me. I appreciate it.
Always a pleasure.
It is always, yes.
Yep.
And we will meet again in the new year. And meantime, have a Merry Christmas and a Happy New Year.
Yeah, you too.
Thank you. Before I leave off, I have just one last question to answer, which was on the super chat. Please do not take super chats when we're having these kind of discussions, because I really do not have the liberty to answer those questions. But taking this one, can we still apply spouse non-accompanying and sponsor her later once I get my PR? Yes, nothing has changed. If you declare your spouse is non-accompanying, you provide all the medicals, police clearances, and all the information correctly in your application as non-accompanying. And once you do become a permanent resident, you can absolutely sponsor your wife or spouse or partner at a later date. There is no problem with that. Well, guys, thank you so much. Thank you for joining in. This was a very enriching discussion with Steven. As I said, he's got so much wealth of wisdom there and information about different aspects of immigration. we will definitely have him again here in January, when we will talk more about what's in store for us in 2024. Until then, thank you so much for joining in. Take care, and I shall see you next time.